in 1932, as you can guess from the sign, we are introduced to something called the neighbour principle. And the neighbour principle comes from probably, well, it's our snail again, but probably one of the most important cases in British legal history, Donoghue versus Stevenson. And the neighbour principle is formulated by a judge called Lord Atkin. And the facts of the case, I mean, we could literally spend a whole video just looking at Donoghue versus Stevenson. But what I will do is I'll give you a very brief overview of the facts of the case. We'll look at it again, perhaps in one or two other videos at different levels. And you may want to spend some time really digging deep into Donoghue versus Stevenson. It's one of those landmark cases that changes the shape of English law. And in Donoghue versus Stevenson, Mrs. Donoghue and a friend visit a cafe. It's in Glasgow. Mrs. Donoghue's friend buys her a bottle of beer. It's a bottle of ginger beer, actually. And the bottle is made of opaque glass that you can't see through. Mrs. Donoghue has a drink, and then she refills her glass. And as she refills her glass, the remains of a decomposed snail pops into her glass. Now she's already drunk some of this liquid, and now all she's doing is now seeing, as she tops up, that the liquid that she's been drinking has been contaminated by a snail that has somehow found its way into the bottle at the factory. Mrs. Donoghue develops gastroenteritis, quite a severe stomach bug, as a result of drinking this contaminated ginger beer. The problem is that in 1932, Mrs. Donoghue had not bought the bottle of ginger beer. Her friend had bought it for her. And because she had not bought the bottle of beer, she could not make a claim against the manufacturers in contract law under a breach of warranty, because this legal concept of duty of care didn't exist. The House of Lords had to decide whether or not a duty of care existed as a matter of law, whether or not we have a legal obligation to take care of people around us, rather than a more direct contractual obligation that you enter into, for instance, when you would have bought the beer in this case. And the Lords held that the manufacturer did owe a duty of care, and that duty of care was to make sure that the bottle did not contain foreign bodies which could cause her personal harm. In summing up the case, Lord Atkin comes up with this very, very famous statement. And it's a development of the negligence issue in Blyth. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Now, I'm going to just stop there for a minute. Because what we should be doing now as lawyers is every time we read something like this, we know what an act is, we know what an omission is, we know what reasonable foreseeability is. But this is a new term. What do we mean by neighbour? Does it mean the person who actually lives next door to me? Does it mean the people who live in my village? Does it mean the people who live in a 5-mile radius, a 10-mile radius? Does it mean everybody in Great Britain is my neighbour? And that's what Atkin does. He goes on to say, who then in law is my neighbour? And he defines that by continuing, the answer seems to be the persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Now there's one thing you've got to say for judges. They're brilliant at using 45 words when 2 would do. But in short, what we mean and what we mean by, or what Atkin means by this, is that if we take that as an example, if I'm out driving my car on the roads in, let's say, London, the things that I do in that car, or the things I don't do in that car, stop at red lights and so on and so forth, I need to consider in relation to the people that are on the road in London, close to me, around me. There will be people on the road all over the country. They are not going to be my neighbours. My neighbours will be those people who are on the road around me at the time, because they will be closely and directly affected by my act. If you think about Donahue versus Stevenson, a manufacturer of a ginger beer bottle who then ships their bottles all over the United Kingdom for consumption, it's fair to say that anybody that drinks that ginger beer would be closely and directly affected by my act. So it doesn't necessarily mean, the neighbour principle doesn't necessarily mean that you've got to be close to you. It's a concept, it's a much larger concept, and it's about whether or not they are closely and directly affected by my act. Now, this is based on the biblical command about loving my neighbour. And it means that for the first time in 1932, there is a liability created without a contract. And this means that the law of negligence can develop. We can have a situation in which people can seek remedy for being wronged without having a previous contract with the defendant. Now, that's all well and good.